reaction to the preliminary hearing is we think the judge made the right decision. We don't think that the facts asserted by the Commonwealth in the preliminary hearing substantiated the aggravated assault felony or the reckless endangerment, primarily because both of those require either a serious bodily injury or the intent to commit a serious bodily injury as the baseline for those charges, and I don't think that was met. So I think the judge made the right decision, which leaves us with 2 counts, the simple assault and the endangering the welfare of children, and those will be addressed at trial. And this is a difficult case. I understand the district attorney's position because they have a child that was brought to them with, and they have an expert telling them that it's bite marks, and as a DA, they want to know who bit this child. On the other hand, as a defense attorney, I have a credible, educated mother who is saying this didn't happen, and not only her, but she took this child, went to multiple doctors, none of which thought that these were bite marks until they finally found one that did, and that's when this all came about. So there's conflicting issues and conflicting testimony as to what this is, and at the end of the day, it's the judge and the jury's job to come to the truth, and that's ultimately what will happen in this case.
Has anyone indicated what else it might be other than bite marks?
There was testimony on the stand from the government's doctor when Michael Galantino, the prosecutor, put his doctor on the witness stand. We did ask whether these circular lesions can happen, and while it was her opinion that they are bite marks, she did acknowledge that there were upwards of 15 other conditions that could have circular rashes, so to speak, or lesions such as these.
Okay. You mentioned that this was a difficult case. Can you just kind of touch on how unusual it is?
Well, it's a difficult case from a legal perspective because, for one thing, no one but God knows for sure what happened in that room other than my client and her son. And her son at the time was 2 years old. So, this is an example of the legal profession trying to use circumstantial evidence to put together the facts of what happened in a specific scenario. And this is not all that unusual. I mean, often we ask juries to try and figure out what happened when the only people that really know what happened are the people sitting at the defense table, or, for example, in a homicide or something else, someone, the victim's not present. We're dealing with that right now in the national media with Trayvon, with the Trayvon Martin trial. The only person alive that really knows what happened is the defendant in that case that didn't take the stand. And that's the district attorney's position here, and that's their issue. Obviously, we don't believe our client did anything wrong, so we believe they're trying to prove something that doesn't exist and didn't happen. And that's where our system goes on trial, and they have to prove it guilty beyond a reasonable doubt. We don't think they can make that burden here, and hopefully this will result in a mother being reunited with her 2 children so they can live happily ever after, so to speak.
Cool.